Good morning, everyone. We have an outstanding panel here for you this morning, and I think it's no exaggeration to say that the 5 panelists sitting here today are 5 of the leading scholars, leading constitutional scholars of their generation. Won't surprise you to learn that the panel before you is not a monolith. In fact, I think the panelists would agree on one thing, and that is that it would be difficult to assemble a greater diversity of viewpoint anywhere. So it's a privilege for me to be able to moderate such a distinguished group. And we're going to proceed here this morning in 3 steps. We're first going to have opening statements from our panelists of 5 to 7 minutes. And I'll be something of an ogre in keeping those statements succinct. And then I want you to hold on to your seats, because the panelists are going to go at each other with questions and discussions and ripostes and the like. And then our third stage is we will want some questions from the audience, not speeches, but some good questions. And the idea this morning is going to be to keep it moving. The topic could not be more timely, could not be more important. The title is Enumerated Powers, the 10th Amendment, and Limited Governance. And that's a long and fancy way of saying, is the federal government grown too large? Is it doing too much? Has it transgressed lawful limits? Is the federal-state relationship out of balance? Is anybody in this room willing to answer any of those questions? Yes? Well, okay, if you do, your job is only half done, because the question our panelists are going to grapple with is, what responsibly can we do about it? Now, I want to get into the discussion without further ado, and I will ask each of our fine panelists to accept my apologies for not giving them a flowery introduction. You can read it in your programs. If I said everything that these 5 wonderful folks have done, it would consume all of our time. So I'm going to ask Randy Barnett to be our leadoff hitter, and he is the Carrick Waterhouse Professor of Legal Theory at Georgetown University Law Center. Randy?
Thank you, Judge. This morning I want to question the conventional conservative and libertarian wisdom about federalism that I believe views the original meaning of the Constitution through 2 highly distorted prisms. The first is the prism of the Reconstruction Supreme Court, with its hostility towards the 14th Amendment that was drafted by Republicans in the 39th Congress. The second is the prism of the New Deal Court, with its hostility to the enumerated power scheme in the original Constitution of the Founders. In place of the original constitutional scheme as formally amended, many conservatives and libertarians have adopted instead, I believe, a post-New Deal scheme of virtually unlimited federal power with special carve-outs or special protections for sovereign states. And these carve-outs, I think, are not coincidentally analogous to the carve-outs for special rights. Now, I've just given you my conclusion, so you know where I'm heading. So let me now start the story from the beginning. Because I only have a few short minutes, and I think the judge will feel free to cut me off, I'm going to have to do this as a very quick and dirty constitutional history in which I'm going to oversimplify, inevitably, a more complicated story. and I'm going to have to speak rather quickly also. So let me start at the beginning. In the beginning, the Constitution replaced the Articles of Confederation, which was essentially a treaty among semi-sovereign states, with a new national government ratified by the people themselves in conventions. Under this system, it was important that the national government have certain powers that were lacking under the Articles, but it was also very important that states had a great deal of power over their own citizens. How much power? Well, enough power to authorize some of their people to legally own others of their people. Now that is a whole lot of power. This was accomplished by granting the new national government only limited and enumerated powers that would have nothing at all to do with slavery within the existing states. The scheme of limited and enumerated powers was crucial to the maintenance of this state autonomy with respect to its domestic affairs, and the original meaning of the Constitution reflects this imperative. Now, this is not to say that states had an unlimited power, which was then as now the definition of tyranny or despotism. Rather, their powers were almost exclusively limited by the constraints provided by their own constitutions, some of which were more Republican than others, to say the least. However, the slave power was not long content with the states' rights system and demanded increasing power. Indeed, the Southern states hewed to no consistent principle with respect to federalism. Their only consistency was with respect to slavery. So on the one hand, they argued that Congress had no power to abolish slavery in the District of Columbia or the territories, notwithstanding that it certainly looked like Congress had a police power over both domains. But on the other hand, and more ominously for the Union, it claimed that Congress had the power to enforce the Fugitive Slave Clause under Article 4, Section 2. This claim was made early on when Congress enacted the first Fugitive Slave Act of 1793, but it was not until 1842 in Prigg versus Pennsylvania that the Supreme Court upheld the statute by finding an implied congressional power to enforce the Fugitive Slave Clause. Now, this was highly significant because all the provisions of Article 4 could be considered to be terms of a compact between the several states to be honored by comity. Just as treaties with foreign nations do not expand the delegated powers of Congress, nor do these articles of compact of treaty among the several states expand the delegated powers of Congress. That Congress lacked any power to enforce these articles is evidenced by the exceptional grant of power to enforce the full faith and credit clause of Article 4, Section 1, which reads, "And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved in the effect thereof." Now, with this implied power established, Congress then went on to enact the Fugitive Slave Act of 1850, which threatened the autonomy of the free states and set the stage for the rise of the Republican Party and eventually the Civil War. With the Civil War, the Republicans in the 38th Congress enacted the 13th Amendment, eliminating the power of states to enforce slavery within their borders. But Southern states almost immediately used the rest of their vast police powers under the original scheme to enact black codes to restrict the economic and personal liberties of the freedmen with the aim of approximating as closely as possible the subordination of slavery in everything but name. Their police power, coupled with their countenancing of private violence, allowed these states to go a long way towards resubordinating free blacks and making life treacherous in the South for white Unionists and Republicans. In response to this, the Republicans of the 39th Congress enacted the 14th Amendment, Section 1 of which was designed to alter the pre-existing system of federalism to seriously curtail the power of states to violate the fundamental economic and personal liberties of their own citizens. And remember that slavery was first and foremost an economic system. The reaction of the South to this and other measures to restrict their powers was a campaign of terrorism unwitnessed in this country before or since, from lynching up to and including mass murders. Even before this campaign of terrorism had the effect of disillusioning Northerners into withdrawing federal troops from the South, much like the terrorism of the Sunnis against the Shia in Iraq was designed to demoralize the American public into withdrawing U.S. troops. Beginning with the slaughterhouse cases, the Reconstruction Supreme Court began to systematically gut the 14th Amendment to restore the previous discretionary powers of the states over their own citizens. It was not until the so-called Lochner era that the Supreme Court began gradually restoring the effect of, if not the letter, of Section 1. But this effort by the court was bitterly opposed by progressive Republican and Democrats who favored the rights of states to enact progressive economic legislation in coalition with Southern Democrats who favored the rights of states to enact economic systems of Jim Crow. Beginning in 1929, progressive Republican Herbert Hoover began appointing justices who would uphold progressive legislation at the state level. And as we know, when Democrats took control of Congress, President Roosevelt finished the job by appointing the rest of the New Deal Court, which gutted the enumerated powers scheme so that Congress could regulate the national economy. They did so by relying on the necessary and proper clause to allow Congress to reach wholly intrastate economic activities that had a substantial effect on interstate commerce. Eventually, however, a split developed among the New Deal justices that began to be noticed even by such ardent New Dealers as Arthur Schlesinger Jr., who coined the phrase judicial activism to describe those New Deal justices who were inclined to protect certain fundamental rights. This split was to become much more pronounced during the Warren Court, with some justices willing to protect some enumerated and unenumerated rights over the vehement protest of their judicial conservative brethren. In the 1980s came the Reagan Revolution, with the efforts of Attorney General Ed Meese and his call for a return to the jurisprudence of original intentions. But this was also coupled with an affirmation of the judicial conservatism of old New Dealers like Raul Berger against the activism of the Warren Court, which brings us now to the new federalism of the Rehnquist Court. Rather than return to the pre-New Deal scheme of limited and enumerated powers, the Rehnquist Court attempted to preserve the New Deal vision of national economic regulation while drawing a line at the power to regulate non-economic, intrastate activities such as the possession of guns within 1,000 feet of a school. But with Congress holding power over all economic activity in the land, what was to become of the states, much of whose activities were economic in nature? The solution was affirmative carve-outs for states that were functional equivalent of protecting the special or fundamental rights of individuals, and thus was born the anti-commandeering doctrines of New York and Prince. But the so-called New Deal settlement was not to be unsettled. So today, 30 years of Republican judicial appointments has left us largely defenseless against the most naked power grab by Congress since the New Deal, the nationalization of our health care system. Given New Deal precedent that only one justice of the Supreme Court shows any willingness to reconsider, we cannot realistically challenge the law that turns private insurance companies into federal public utilities. Instead, the legal challenge must be limited to where the Democrats in Congress went, where no Congress had gone before, mandating that the citizenry at large engage in economic activity. But that is the subject for a session later this morning. Today, the American people are now out in the streets demanding a return to the written Constitution with its scheme of enumerated powers. This political movement is a first and necessary step to restore the system of constitutional federalism designed by the founders and modified by the Republicans in the 39th Congress. For without such a political movement, we will never get a president who will nominate and a Senate who will confirm justices of the Supreme Court who will repudiate the Reconstruction and New Deal precedents that prevent us from restoring the federalism of the lost Constitution. Thank you.
Randy, thank you so very much. I'm next going to call on Mark Tushnet, who is the William Nelson Cromwell Professor of Law at Harvard Law School. It's a pleasure to welcome Mark. He and I were clerks on the Supreme Court together. He clerked for Justice Marshall while I clerked with Justice Powell. He was a delight to be with then, and I know you'll find him a delight to be with now.
Thank you. I want to address the second half of the question that Judge Wilkinson posed at the beginning, which is what to do about things. So, and I'm going to speak in quite general terms. If you think the government's too big, what can you do? If you think the government's too small, what can you do? If you think it's doing the wrong things, if you think it's not doing what it ought to be doing. The obvious answer to the question, what do you do about it, is that you win elections. But there are two problems with that. One, if you win elections, you can lose elections. And so you have some interest in figuring out some way to entrench your policy positions in reasonably permanently. The other problem is that there are some things that you might want to do that are actually precluded by the existing Constitution. There'll obviously be disagreement about what those things are, but both with respect to the risk of losing elections and thereby losing whatever policy gains you've made, and with respect to the problem of things that you want to do that the Constitution, as it's being interpreted, keeps you from doing, the obvious remedy is to amend the Constitution. So you have to win elections, and then to entrench your policy victories, you might have to amend the Constitution. And I'm actually in favor of amending the Constitution in a variety of ways. I'm not an anti-amendment kind of person. Obviously, we'd have disagreement about what things ought to be amended, but that's what you thrash out when you try to do it. The problem with the amendment route is that politicians actually have very few incentives to seriously pursue amending the Constitution, even if they've won an election. And the reason for that is twofold. Well, divide the kinds of amendments you might want to do into two parts, two segments. One are substantive amendments restricting the scope of the national government, for example, saying you can't do certain kinds of things. And the other is procedural, something like the amendment Randy has gotten behind about having a state override of national legislation. With respect to substantive amendments, the problem is this: from a politician's point of view, I'm not talking about good public policy. From a politician's point of view, again, this gets complicated given the structure of the Constitution, but if you have the votes to submit votes in Congress to submit amendments to the states, you have the votes to do what you want to do. And you have a limited amount of time and political capital, so you do what you want to do, and then maybe if there's time left over, you might make some effort to get an amendment that would be submitted to the states, and I'll come back to, but there are problems associated with that, again, from your point of view as a politician. That's the route that's been used to pursue amendments. There's another route, which is to convene a constitutional convention upon the call of the states. That will make sense given this assumption that you have enough votes to enact the substantive legislation. That would make sense if there are certain arrays of divided government and sufficient control over state legislatures to get the right kind of call for a convention. And then there's a long footnote here and there are all sorts of procedural questions about how you go about convening a convention and what it could do. And those questions would pose a political obstacle to getting a convention called, even on the submission of the states. So given the difficulties of actually getting a substantive amendment to the Constitution, a politician sensibly would focus his or her attention on getting the substantive legislation enacted and then trying to figure out some way to defend that legislation politically by generating constituencies of support for the policy position that's been established. Think here actually of Medicare and the constituency of support that gets created by creating the Medicare program. The second kind of amendment is a procedural amendment. And here the difficulty, again, from a politician's point of view, is pretty straightforward, divided in two parts. One is that the payoffs are in the future. That is, if you have the state veto or override mechanism or any other procedural mechanism, you're not going you, the current politician, are not going to get anything out of it. What you'll possibly be buying is in the future if the Congress the composition of Congress changes and you start losing policy positions, you might get a payoff later on in a state override of the policies that have been adopted. Again, you can adapt this to whatever the procedural mechanism is, but the major point is that the payoffs are in the future, and the payoffs are uncertain because, first of all, there's no guarantee that if you submit an amendment to the states, even if you've got the requisite votes in the Congress, there's no guarantee that it's going to be adopted. And then secondly, the uncertainty is about the actual deployment of the mechanism with respect to whatever it is that you're concerned about. And so the possibility of what I would call good government reforms, again, from whatever point of view you take about what a good government reform is, the possibility of entrenching good government reforms by the constitutional amendment process is quite small. It's not zero. The reason it's not zero is that sometimes the things that you can't do by legislation are really, really messing things up. The best example here is the situation with respect to the right to vote for people over the age of 18. The Supreme Court said that Congress could pass a statute extending that right to vote in federal elections, but couldn't do it in state elections. That created an administrative nightmare for the states. And within, I think it's 9 months, a constitutional amendment to require the 18-year-old vote at the state level was adopted. I think not because of the people at the state level were convinced that it was a good policy position. Maybe they were, some of them were, but mostly because it was just going to be an administrative nightmare to set up 2 systems of voting. Okay, so there are some possibilities for the amendment process, but I think they're relatively rare. Final point is, of course, politicians propose amendments a lot. They're submitted with some regularity. What's going on when they're doing that? Well, I think what's going on is what political scientists have called advertising. They're basically proposing an amendment so that they can send out a press release, not so that the Constitution will actually be amended. A sort of, I don't know, mildly critical way of putting it is that when a member of Congress or a state governor, in the kind of case Randy's pursuing, supports a constitutional amendment, from the politician's point of view, it's not really a serious policy proposal, although, again, the politician may agree with it on the merits. Rather, it's a way of getting some press for the politician about the position that the politician's taking, maybe in order to get more support for enacting whatever the policy is as a statute. So just to conclude on the what can you do about it side, from a constitutional scholar's point of view, I'm not interested in the question of winning or losing elections. I mean, as a citizen I am, but as a scholar I'm not. What I'm interested in is sort of thinking about how the constitutional amendment process might be used to entrench policy positions of whatever sort. And although I would like to see more amendments occurring to our Constitution, I'm very skeptical about whether they will actually occur. Thank you.
Mark, thank you for those thoughtful remarks. And we're now going to turn the podium over to Professor Michael Paulsen, who is the Distinguished University Chair and Professor at the University St. Thomas School of Law. Michael?
Thank you, Judge. First, the bad news. Can you take a little bad news? Washington, D.C. remains in substantial part enemy-occupied territory for those who favor limited government. any serious, meaningful, permanent reforms that would effectively limit national governmental powers are highly unlikely to make it through both houses of Congress and be signed into law by this president. In addition, as Mark has noted, any constitutional amendment proposals have to get 2/3 votes of each house of Congress. The chances of this happening are exceedingly slim. Even more depressing, I think the courts are likely to uphold the constitutionality of Obamacare, including the individual mandate, as a valid exercise of the commerce and necessary and proper clause powers and probably the spending clause powers. All is not right with the world. Probably the only realistic way to achieve meaningful, permanent, serious constitutional reforms limiting the power of national government is to pursue the other alternative mechanism for amending the Constitution, which is the convention method of Article 5. The good news, at least I think it's good news, is that such an Article 5 constitutional convention for proposing amendments may be closer than you think. The title of my talk, and there's a handout floating around for some of you, is called How to Count to 34. 34 is the magic number. 2/3 of the state legislatures must apply for a constitutional convention. 2/3 of 50, nearest whole number larger than that, is 34. And once you reach the magic number of 34, Congress is constitutionally obliged, has a ministerial duty to convene a constitutional convention. Well, I'd like to just hit 4 quick points, spend about 1.5 minutes on each one, about the constitutional convention method, about how you go about counting to achieve that 34 for a constitutional convention. So I'm going to address 4 questions. First, can there be such a thing as a limited constitutional convention? My answer, and I think the better consensus answer, is that no, there cannot be a limited constitutional convention. Any convention for proposing amendments must be general in the subjects it can consider. The second question I'll address is, well, then what do you do with all of these state constitutional convention applications that seem to contemplate a specific subject? My answer is that some of them are invalid because they're conditioned upon being a limited constitutional convention, which you cannot have, but some of them are actually valid applications for a general convention, and all they do is recite their subject matter agenda. My third question I'll address is, what do you do if a state has submitted multiple applications, some of which are valid and some of which are invalid? My answer is that sometimes the invalid ones repeal the valid ones, but usually they do not. They often leave in place prior valid general constitutional convention applications. Then the fourth question I'm going to address is, well then, can you cumulate applications over time and across subject? And the answer is yes, you can. And that may be the route to get us close to a constitutional convention. Okay, a few words about each. First question was, can there be such a thing as a limited constitutional convention? In other words, when we're counting to 34, what is the result that we are counting toward? I think the better answer by far is that constitutional conventions are independent constitutional agencies that may propose whatever they feel they wish to propose. As a matter of the text of the Constitution, Article 5 merely refers to a convention for proposing amendments, the most natural sense of which is that it may propose such amendments as a convention sees fit to propose. Where Article 5 imposes limitations on the proposing body, it does so explicitly. There are a couple of checks. Congress chooses the ratification method, and you have to have 3/4 of the states ratify. But that's the only limitation embodied in the text. In addition, there's a structural constitutional argument. Congress may propose constitutional amendments, and it may propose whatever it wants. The convention method was clearly contemplated as an alternative parallel method. Logically, a convention must have the same powers of proposing as the Congress would have had. History bears this out. At the time we're ratifying the Constitution, and people are thinking about what can constitutional conventions do, they have an example before them of the Philadelphia Convention of 1787, which vastly exceeded its mandate and proposed whatever it was it wished to propose. In addition, part of the reason the Bill of Rights was proposed in Congress was to head off the idea of a second constitutional convention. James Madison, the patron saint of the Federalist Society, was concerned that any convention could completely undo what had been done before. They clearly contemplated the idea that conventions were unlimited in what they could propose. Finally, there are endlessly difficult, intractable problems of what you would do if you were going to have a limited constitutional convention. Do the state applications all have to say exactly the same thing? Who enforces the limitation that is supposedly governing the convention? Congress? They're precisely the body that you were trying to get around. They were meant to be a pass-through. The convention was meant to be an assembly of the people to propose what it wants. Now, this strikes fear, I find, in conservative audiences. You get this split between sort of, you know, the button-down, starched shirt, real, true conservatives who fear a constitutional convention, and then you get the rabble-rousing redneck Tea Party types who say, yeah, bring it on, bring it on. My general reaction is that you shouldn't fear a constitutional convention. What it has the power to do is to propose only. Any proposal has to be ratified by 3/4 of the state's legislatures, and that is a difficult process. It is unworthy of you, I submit, to be afraid of a constitutional convention. That's sort of being afraid of the framers' intention as to how this document would be amended in a way that doesn't depend on Congress. Okay, that's question number one. I think you're counting toward a general convention. What do you then do with all of these state applications that at least appear to ask for a limited convention? And the simple answer is not all of them actually do limit their application to a specific subject. There are many applications that are conditional, saying we want a constitutional convention only if it is explicitly limited to this subject and no other. That is invalid because it does not constitute an application toward a valid constitutional general convention. But most of these applications, or at least a great many of them, say we want a constitutional convention because we want to propose a balanced budget amendment or a term limits amendment. Where it does not contain words of restriction, I think the most natural interpretation is that these are applications for a general convention that recite that state's specific subject matter, purpose, or agenda. It's what their ideas are. So that actually, in some sense, becomes a little bit irrelevant whether you have a limited convention view or a general convention view, because the key thing is what does the application actually say? And if you construe it in terms of the counting rule that actually counts, you can construe many of these applications that recite a subject matter as actually valid applications for a general convention. Third question, what do you do with multiple convention applications, some of which are valid and some of which are invalid? I sketch out a little door number one, door number two, door number three. One interpretive approach is you could say, well, we're going to sever the invalid limitation and just treat it as a general constitutional convention. I think that's clearly wrong. The intention to have a convention specifically limited, if that's what the application says, has got to be enforced. Door number two is that the limitation is invalid, but what this means is that the convention application is invalid, but then it just operates as a legal nullity. And I contrast that to the third interpretive option, which is that a convention application that's invalid somehow would repeal by implication everything that's gone before. Now, repeals by implication are strongly disfavored in the law, and there are many good reasons for believing that this is not the correct understanding of these convention applications. So the correct interpretive method, I think, is you look at the most recent state constitutional convention application. If it's invalid, you go to the next previous one unless the invalid one has specifically revoked everything that's gone before. Okay? Now, can you accumulate then valid constitutional applications across subject and over periods of decades and years? And I think the answer there is yes. Now remember what we're talking about. There is a valid, unrepealed state constitutional convention application. It's a species of state legislative enactments. Laws have unlimited life unless they are repealed or rescinded by subsequent act of the legislature. In fact, this is the premise under which the 27th Amendment to the Constitution, the anti-congressional pay hike amendment, which was proposed in 1789 and ratified in 1992, can become valid. We accumulate ratifications, valid ratifications, over time. I think by the exact same reasoning, you can accumulate this state's 1936 application for a constitutional convention that's general with this state's 1972 application for a general convention. They talk about different subjects. And you can, applying this method, reach the desired result of 34. Now, has anybody ever looked at this? You know, when I was a young pup law professor, I wrote this article and sent some research assistant to gather every constitutional convention application. We looked at all 399 of them, and back in 1993, when I was 12, we concluded that there were 45 states whose lights were on for a constitutional convention. Now, I've updated the research, and I want to thank the University of St. Thomas law librarians, because this is quite a Herculean task, because we've now looked at over 460 constitutional convention applications. And what I found was, I don't know whether to be cheered or annoyed by this. Every scholar has the delusion that what they say will, actually be picked up and people will take it seriously and it will work some magic constitutional reform. And I had this ambition that this would lead to a great constitutional convention. Instead, it appears that people read my article and others and thought, oh my gosh, we have to pass rescissions and withdraw all of our constitutional convention applications. And about 8 or 9 or 10 states have been doing that. Arizona, Georgia, Idaho, Montana, New Hampshire, North Dakota, Oklahoma, Oregon probably, South Carolina, South Dakota, Tennessee, Virginia, Wyoming have been switching their lights off for a constitutional convention. My gosh, we don't want a constitutional convention. We hereby rescind everything we've done before. Now notice it actually helps my interpretive argument that you should not otherwise construe a general application. Oh. Add them up, what do you have? You have 32, and you're right on the cusp of a constitutional convention. And many of these states that have turned off their lights are red states, sometimes with new changes in legislatures. If people want a constitutional convention, we're just 2 states away.
Thank you so much, Michael. We now turn the platform over to Michael Gerhardt, who is the Samuel Ash Distinguished Professor in Constitutional Law and the Director of the Center for Law and Government at the University of North Carolina School of Law. Michael?
Thank you, Judge Wilkinson. I must say that I fear having a federal judge stand up next to me in an effort to silence me, so I am going to try my awful best not to have that happen. I do, however, want to begin by thanking the Federalist Society for the generous invitation to be with you today. There just simply is no better organization that sponsors dialogues about the Constitution than the Federalist Society, and I always regard it as really the finest privilege I've ever had as a law professor to be invited to participate in your programs that could come to a crashing end real soon. But I really take this with great humility and enormous pride, so thank you for this opportunity. It is especially meaning to me because I feel that I am the last of a dying breed. I think of myself, when I am prone to do this, as a moderate. And I just don't get the feeling that there are too many of us left anymore. This is already far too solemn an occasion. As far as I can tell, this group is unusually solemn and sober this morning. And so I want to at least try to talk to you about how I might view things from the perspective of the last of my kind. Although I do have 3 kids. And so the perspective I want to share with you and talk about is one that I actually have not heard mentioned this morning, and I actually take heart from that it has not been mentioned, that nobody's looking to the courts to save us, that nobody expects the courts to be the institution, to be the one to strike down legislation or to sort of, in a sense, dial us back from whatever brink we happen to be on right now. And frankly, I think that's a good thing. So what I want to do is talk about the perspective of the judicially modest judge. So what's a judicially modest judge supposed to do with all that we face today? And I think the short of the answer is actually already heard in the echoes of a phrase we've heard in the news of late, the trust but verify, great phrase that Ronald Reagan had spoken as president. I want to suggest that the judicially modest judge defers but doesn't abdicate. And I think that's appropriate. And I want to look to 5 judges who've been, to some extent, the model of that and given us that mindset that I would suggest would be where we expect judges to be, not just today, but in the foreseeable future. I go back to 1925, just as a starting point. Fairly arbitrary. I could go back to John Marshall, the great Chief Justice, but I feel more like beginning of the 20th century, just the kind of mood I'm in today. I go back to the Chief Justice in 1925 who said, Congress can certainly regulate interstate commerce to the extent of forbidding and punishing the use of such commerce as an agency to promote immorality, dishonesty, or the spread of any evil or harm to the people of other states from the state of origin. In doing this, it is merely exercising the police power for the benefit of the public within the field of interstate commerce. A remarkable thing to have come from Chief Justice Taft, no, to be sure, but not, I would suggest, an unusual thing for a judge to think or to be the mindset of that judge. Justice Cardozo said perhaps much more famously in 1937, in opinions upholding the Social Security Act, first about the conception of the spending power, he said, this conception of the spending power of Congress has prevailed. Yet difficulties are left when the power is conceded. The line must be drawn between one welfare and another, between particular and general. Where this shall be placed cannot be known through a formula in advance of the event. There's a middle ground, as a moderate I feel somewhat pleased, or certainly a penumbra in which discretion is at large. The discretion, however, is not confided to the courts. The discretion belongs to Congress unless the choice is clearly wrong, a display of arbitrary power, non-exercise of judgment. This is now familiar law. He's speaking in 1937. So what he's saying in part is elections matter. And so I would pick up what Mike just said. I'm not afraid of constitutional conventions. I'm not afraid of politics in the least. I welcome political discourse. I welcome vigorous political discourse. I welcome the opportunity to rethink things in the political sector, and so therefore I'm all for whatever constitutional convention might be possible, and whatever it does is, as a constitutional professor, fine with me. Justice Cardozo went on to say, whether wisdom or unwisdom resides in the scheme of benefits set forth in Title II of the Social Security Act, it's not for the courts to say. The answer to such inquiries must come from Congress, not the courts. The court's concern here, as often, is with power, not with wisdom. But there is more. If we kind of fast forward to the present, I turn to another Republican justice, Justice Freed on the, judge, I should say, Massachusetts Supreme Judicial Court. In response to the notion that states could somehow simply refuse to comply with the new health care legislation, he said that a notion that a state can choose to opt out is just preposterous. One is left speechless by the absurdity of it. Now, I do tread on somewhat unsteady ground when I suggest that Justice Freed might be a judicially modest judge. I'm on even less stable ground when I suggest that we can hear the echoes of this kind of modesty in Justice Scalia when he refers to substantive due process on behalf of the protection of economic rights as an oxymoron, something he's long opposed, long does not support. But let me finish with a different judge who spoke about this in the year 2000. And I think what he said still echoes today. It's still true, and actually might well be prescient in foreshadowing what I think the court would say later in a case Randy doesn't want to hear about, Gonzalez versus Reich, Justice Scalia's concurrence in that opinion, which I think is a very strong, expresses a very strong support, at least constitutionally, for the federal program there. And so in 2000, this judge says this: the judiciary has the duty to ensure that federal statutes and regulations are promulgated under one of the enumerated grants of constitutional authority. Moreover, the judiciary has a duty to independently evaluate whether a rational basis exists for concluding that a regulated activity sufficiently affects interstate commerce. That restates, of course, the doctrine as we know it. He goes on to say, if we were to decide that this regulation lacked a substantial effect on commerce and therefore was invalid, we would open the door to standardless judicial rejection of democratic, that's small d, democratic initiatives of all sorts. Courts need not side with one party or the other on the wisdom of this endangered species regulation. we hold only as a basic maxim of judicial restraint that Congress may constitutionally address the problem of protecting endangered species in the manner undertaken herein. The political, not the judicial process, is the appropriate arena for the resolution of this particular dispute. I agree with that, Judge Wilkinson. I think that is very well said. And I think that is, in fact, the judicial mindset we can expect the courts to have now and the foreseeable future. And so I think that as we sort of think about what we want to do about refashioning constitutional law, I think that our mindset is already disposed in the right direction. We're thinking politically, not judicially. And I think that's exactly where Chief Justice Roberts and perhaps Judge Wilkinson and others would prefer that we think. And as a constitutional law professor, I perfectly welcome a vigorous political process. And as I said, elections matter, and they will matter in the future. And I think that's good for all of us.
Thank you very much, Michael. And batting cleanup today will be Ted Cruz, who is a partner at Morgan, Lewis, and Bockius, and a former Texas Solicitor General, and perhaps most illustriously of all, a former Fourth Circuit alumnus. He was a law clerk for my friend Judge Mike Ludig before he went on to clerk for Chief Justice Rehnquist. Ted, we're so happy to have you.
Thank you, Judge. May it please the court. Good morning. It's great to be with so many friends. You know, in preparation for this morning's panel, I did a little bit of research this weekend. And I discovered that this is, in fact, the 6,342nd panel at a Federalist conference on federalism. This is a topic that the people in this room have cared about a long, long time. But what's remarkable is today, somebody outside this room cares. We are in a remarkably different time. A lot of us remember when this gathering didn't pack this room out of the walls and wasn't standing room only. A lot of us remember years back when the Federalist Society seemed like it was a couple of dozen law students and lawyers and law professors enjoying some fine wine with Leonard Leo and getting beaten at poker by Judge Kaczynski. The incredible thing about this topic now is for the first time in a long, long time, there are a whole bunch of people not at the Federalist Society that are focusing very closely on enumerated powers, on the 10th Amendment and limited government. There is a real potential that the topics we're talking about right now will make a real difference. You know, Michael referred to the rabble-rousing redneck Tea Partiers, which is a label I will happily embrace. And being a Texan, I intuited there was something mildly pejorative about that, but I have no idea what. If you look at the Tea Parties, if you look at what's going on nationally, it is nothing short of remarkable. There are quite literally millions of people across the country that are gathering publicly carrying the United States Constitution. Ordinary men and women, not lawyers, not FedSoc geeks, just men and women living their lives that are going and rereading the Constitution and getting motivated in the public policy process to stand up and do something about it. That's really quite remarkable. Earlier this year, I began serving, in addition to my day job as a practicing lawyer, began serving as a senior fellow at the Texas Public Policy Foundation and leading their Center for 10th Amendment Studies. One of the things we did today is released this morning a study on the 10th Amendment and on the diminishing legal constraints of the federal government and laying out a potential plan of attack to do something about that. One of the things we also did is we did a nationwide survey of registered voters. some very interesting results, one in particular. Do you know that 33% of registered voters said that they had read the U.S. Constitution in the past year? That's astonishing. That's not 33% of lawyers. That's not 33% of Federalist Society members. That's not even, God bless them, 33% of Texans. That is 33% of registered voters nationwide said in the past year they had read the United States Constitution. And I'm going to suggest, actually, most of us in this room are fans of federalism, fans of real constraints on the authority and power of federal government. I'm going to suggest that, ironically enough, the single best friend federalism has had in modern times is President Barack Obama. And there's a reason for that. There's a reason for that that's very simple. It goes back to Sir Isaac Newton's third law of thermodynamics. For every action, there is an equal and opposite reaction. The last 2 years have seen the most dramatic increase in federal power, spending, and authority this nation has ever seen. And the reaction has been fabulous. I'm going to suggest 3 specific things that are happening in reaction that have the potential to transform federalism, not just into a topic that each of us gather in the Mayflower once a year over drinks to share and bemoan and yell at the sky about, but actually to do something positive. Number 1, the Attorney General lawsuits challenging Obamacare. Now, I'm going to respectfully disagree with Michael on that. In my opinion, these lawsuits, when they were first filed, you had lots of legal pundits who explained they're frivolous. They have no business being filed at all. And yet, in both the Florida case and Virginia case, those cases have now survived motions to dismiss with long and serious opinions written by the judges considering them. My day job is serving as a Supreme Court litigator. In my opinion, there is a substantial chance these cases will yield ultimately a decision by the United States Supreme Court concluding that the individual mandate exceeds the authority of the Commerce Clause. In my judgment, it is more likely than not that there are 5 votes on the court for that proposition. And if that's right, that will be a very important holding. The second area of substantial potential change going forward is constitutional amendments. And I agreed with every word Michael said. I thought that was fabulous. You know, there are those that fear constitutional amendments. And I also agreed very much with what Mark said, that if we look to politicians in the Beltway to produce it, we're going to be looking a long, long time. Oddly enough, self-abnegation is not a natural instinct for elected politicians. They're not fans of creating change to take away authority from themselves. But the incredible thing about this moment in time is that the people driving things right now are, quite remarkably, the people. And the amendment process in the states, in my opinion, will go forward. We will see a real move in the coming year to move forwards to calling a convention. And, you know, there's a classic divide because as lawyers, we often think law has to solve everything. I think the answer to much of the concerns about a runaway convention falls in the divide between law and politics. If 34 states call for a convention, and I think they should, those 34 states, in my opinion, should at the same time express their views that the focus of the convention should be on limiting the power, authority, and spending and taxes of the federal government. Now, I agree with Michael, that doesn't necessarily act as a legal constraint binding the convention as a matter of law, but as a political matter, it certainly does. Because the danger of a runaway convention, of some convention proposing, let's just throw the Constitution in the trash and adopt our favorite little tract instead. The danger of that, I view, is essentially zero, because they can propose it, but it's got to be ratified by 3/4 of the states. And that's a substantial check, in my opinion, if the call is focused on government spending, power, and taxes. The amendments that will come out of that are likely to be a balanced budget amendment, a line item veto amendment, a supermajority for raising taxes, amendments that are focused very directly on what the American people are energized as never before about. And that's something that fans of limited government should be absolutely thrilled, because we have a potential to see that now that hasn't been for a decade. The third thing I will briefly mention is yet another potential way to constrain federal government, and that is interstate compacts. The Constitution provides different forms of law. One of the forms of law the Constitution provides is that states can form an interstate compact, and one of the things in the report, which is on the publication table in the back, one of the things the Texas Public Policy Foundation is suggesting and working with free market think tanks throughout the country on is getting states together to form an interstate health care compact. Those states would sign a compact that would essentially say, in our states, the provisions of Obamacare shall not apply. Now, if that's just a compact between the states, the Supremacy Clause trumps it. But the Constitution's Compact Clause provides that an interstate compact can get the consent of Congress. And if it gets the consent of Congress, it becomes federal law. As subsequently enacted federal law, it would supersede Obamacare with respect to those states. Now, there are two significant advantages to this. Number one, if a number of states get together, propose this compact, they want out of Obamacare, it puts the elected representatives from those states in Congress in a very difficult position. If you have some moderate Democrats who may be fans of Obamacare in Congress, they're suddenly in a position of telling their home state, no, you can't have what the people in this state want. That is something politicians do not like to do. The second, and even more potent aspect of it, is an interstate compact under the terms of the Constitution does not have to be submitted to the president. It is not subject to presidential veto because an interstate compact simply requires congressional consent. A great many people have pointed out in the next 2 years Obamacare can't be repealed because the president could veto it. The president, in my judgment, can't veto an interstate compact. And there are a great many states that are beginning to look at this very, very seriously as a means of restraining the power of federal government. In my judgment, that's a very good thing. Thank you.
Pick up on what Ted Cruz and Michael Paulsen were saying and pose a question to them. Each of you thinks, Ted and Michael, the Constitutional Convention would be a great thing. It's never been done before in over 200 years of our national existence. We do not know, Ted, what the ground rules of such a convention will be. We don't know how the delegates will be selected. We don't know whether the delegates can be recalled. We don't know whether each state at a constitutional convention gets one vote. Bicameralism has, in the Senate and House of Representatives, have a mix of a population-based representation and a state sovereignty representation. But if a constitutional convention takes place, does each state get one vote? Is New York going to be excited about being at a constitutional convention when Wyoming has the same say as New York? How do we iron that out? Is the convention going to be limited to the terms of the call? Or is the convention, as Michael Paulsen suggests, going to be unlimited? Are we playing with fire? The American Constitution, as it exists, by and large, has served this country well for over 2 centuries. Do we really want to take the chance of trading it in? Somebody said to me, yeah, we'll favor a constitutional convention as long as James Madison can be there, or George Washington, or Benjamin Franklin. But those folks aren't going to be there unless my friend Ted is going to take an engraved invitation over to Mr. Madison and ask him to come. So I ask you, let's be very sober and serious about what's being contemplated here. It would be years before we straightened out the ground rules, and wasn't Mark Tushnet's point correct? That if you have the kind of support to get something through a constitutional convention, to get 2/3 of the states petitioning for it, and 3/4 of the states ratifying it, don't you have the support to work the change politically through the normal processes? So Michael Paulsen and Ted, you put this on the table, I want you to come at me.
Judge, so many questions. I think those are a lot of good questions. My basic approach to it is that Congress has very little, if any, power over the substantive or the procedural work of the convention. It may get the ball rolling. I think it has to name a time and a place and invite states to send representatives. I think they could choose an initial default rule for representation, but I think it's subject to being changed by the convention itself. Now, I thought somebody from the audience would come up with a question like this. It's a brilliant question. So I went back and started reading the records of the Federal Convention of 1787. And they show up and not everybody's there, and so they wait a few weeks, and on the first day they pick a chairman by kind of acclamation. The host state said, well, George Washington would be really good. Everybody agreed. Then they appointed a little committee of 3, I think it was Hamilton, Pinckney, and Morris, to draft up rules, adjourned to the local pub, and said, we'll start meeting on Monday. Now, yeah, we don't have Hamilton and Madison here now, but we have some good people. Yeah, I think that the states would choose who their representatives were and would treat it as a very serious and important process. I'm not at all worried that they would throw out the Constitution. Ted's point is an excellent one. You will never get 3/4 of the states to ratify it, precisely because of the adoration for the Constitution the judge expressed. I think that's very powerful in America. But part of our adoration for the Constitution, I submit, should include an adoration for the Article 5 amendment process that is built into it, and it's not something that we should fear. Some of these questions are difficult. They're uncharted territory, but all of them, I think, have reasonable answers that we can trust the American people in a convention to accommodate.
Ted, why do you want to trade the Constitution in?
Well, what I would like to see in many respects is us to return to the Constitution. However, number one, I don't see any significant danger of the parade of horribles that opponents of a convention suggest. The Constitution at this point is revered in American society. Any convention could propose a whole bunch of wacky amendments, and they would have no prayer of getting ratified. I mean, today, Congress could propose an amendment repealing the entire Constitution. It would get ratified by a round number of states, precisely 0. I think there are ample democratic checks. One of the things we see in Washington is people in the Beltway get very afraid when the people start getting energized and expressing their views. I don't think that's something we should fear. I think that is part of what makes this country unique. I would also point out, with respect to Mark's point about, well, why enact a constitutional amendment? If you have the support to do it, you don't need to do that. That may be true if one's policy views are for creating government programs or expanding government, because there's a natural inertia to government. But if one embraces the views of Madison and Federalist 10, which is that men are not angels and that elected politicians will almost always seek to expand their power, then the single most effective way to restrain government power is to provide a constraint they can't change. There's a spectrum of constraints. Look, I'd love to see this new House establish rules limiting spending bills, limiting taxing bills. I think they should do that immediately. Those have the advantages of being quick and easy to do. They also have the disadvantage of being even quicker and easier to undo. And one principle that is always true in government, there will come a Pharaoh who knows not Joseph and his sons. We may at the moment have politicians scared to death enough to care about limited government, but this ain't going to be the case for long. So I don't want temporary threads that, to use another metaphor, Gulliver can stand up and rip out of when the Leviathan wakes up. I want to chain it down, and we have a moment in time to do it in a way that the next politician seeking to create the center in his home state named after his august greatness finds he or she cannot do.
Now, I next want to bring Mark Tushnet into the conversation. Mark, you made an eloquent plea for elections as a way to work change and to limit overreach of federal power. And Ted and Michael and Randy and maybe others are saying that elections can't be counted upon to work. And the basic reasons, one of the basic reasons that elections can't be counted upon to work is that politicians simply cannot be trusted to limit their own power, that the federal government can't be trusted electorally and politically to turn over substantial chunks of power to the states. What's your response to Ted's point, Mark?
I want to make 2 points. One is that this kind of argument, perfectly coherent, but it does count on the following assumption. Last Friday, I was in Lubbock when Justice Scalia gave his talk. You may have seen a report on it. He called the Constitution of 1789 providential. So the assumption that underlies the argument in favor of amending the Constitution now is, roughly speaking, that the providential hand has happened to come down again, but might be lifted in a few years, right? So that people now happen to want to limit government, and we should seize the opportunity so that when the people's views change in the future, they won't be able to implement their then occurrent views. Now, I'm fine with constitutions, but the point of it's very hard to defend amending the Constitution on the ground of today's current viewpoint, because the point of doing the amendment is to keep the people 10 years from now who might have a different view from doing what they then want to do. It's fine. As I say, I'm fine with constitutions, but the democratic defense of amending a constitution to preclude democratic decision-making in the future, that one's a little puzzling to me. The other point I want to make is just about Michael Paulsen's count. This would get into a more complicated sort of argument about how you make constitutional arguments. I know what his position would be. I just want to observe that for some substantial period, on his account, for some period before 1993 and until rescission number 11 came in, Congress was in breach of its constitutional duty on his understanding of the Constitution. Now, I know what he will say about that. On other views of the Constitution, of how you interpret the Constitution, the fact that Congress didn't regard itself as obliged to act given the accumulation of 45 valid calls for amendment is relevant to interpreting the Constitution.
Randy, I want to ask you and Michael a question. You all seem to have very different views on the role that the courts might play in putting a brake on federal power. Michael Gerhardt made an eloquent plea for restraint. And Randy, I know you felt, well, it seemed to me you were feeling that the New Deal courts and thereafter had simply acquiesced in very large expansions of federal power and federal mandate. I just have a question preliminarily to pose to you, Randy, and picking up on what Michael said. If we were to grant, if judges took it upon themselves to put serious brakes on, let's say, the commerce power, beyond that which the Rehnquist Court put on them in Lopez and Morrison, aren't we ceding a lot of the control of our lives over to judges? Aren't we giving away values of self-governance? The third prong of the Lopez test says that something is falls under the Commerce Clause if it, in its aggregative effects, fails to have a substantial economic impact. Well, a substantial economic impact or a substantial commercial impact, that's kind of in the eyes of the beholder. And what's to keep judges from simply upholding the laws that they personally happen to like and striking down the laws that they personally happen to dislike? Isn't it a real danger, Randy, to bring judges too much into the picture here in terms of slamming on the brakes under the commerce power?
There are just two parts of this. One has to do with the role of judges in general, and one is the specific question you asked about the commerce power. With respect to the role of judges in general, judicial negation is not legislation. Judges saying no to the federal government under the theory of federalism that we have means that other governments, the state governments, would have a power to legislate in that field, or that the people would retain the liberty to do as they please. So just the fact that the federal judge says no to Congress doesn't mean that self-government is over. It means that national governance is going to be replaced or displaced by state governance or individual personal governance. So that's the first answer. And it is the responsibility of the judges to follow the Constitution and put the Constitution above that of the legislature, and they haven't been doing that when they interpret the necessary and proper clause so broadly as to essentially give Congress a plenary police power over the entire country. Now, having said that, I don't think it's necessarily a good idea, and here's where I sort of agree with you, to have judges getting in the business of deciding on whether something is more or less necessary or something is more or less substantial. What they need is a judicially administrable rule of law that they can apply in a fair manner, in a judicial manner. And that's what the Rehnquist Court did with respect to the substantial effects doctrine when it said that Congress cannot reach, under the substantial effects doctrine that had been established by the New Deal Court, Congress cannot reach wholly intrastate activity that is non-economic in nature. That is a bright line rule of law that attempts to distinguish between incidental exercises of power and remote exercises of power without having to do a judicial assessment of remoteness or incidentalness, because something that's non-economic is more likely to be remote from the interstate commerce power than interstate activity that's economic. By the same token, with respect to the individual mandate, let's say, it turns out Congress crossed a line that we didn't even imagine as law professors existed, and that is the line between activity and inactivity. Even in hypotheticals asked by judges with respect to the slippery slope of the substantial effects doctrine, no one thought to ask the question of what happens if Congress wants to mandate activity or regulate inactivity, however way you want to put it. And so, in fact, I think, given Justice Scalia's belief in the existence of the essential to a broader regulatory scheme theory of the necessary and proper clause, that there's got to be a doctrinal limit to that. And the limit, I believe, at least under current doctrine, would be the activity-inactivity line. And a court could administer that line without getting into the more or less necessity of something by simply saying, to the extent that a measure is necessary to essential to a broader regulatory scheme, it cannot be used to reach inactivity. It must be limited to intrastate activity, which is how every Supreme Court decision since the New Deal has said. I mean, let me be clear. It hasn't drawn the line between activity and inactivity. That it hasn't done. But every substantial effects case that's ever been decided has used the term activity. as to what it is that the Congress may reach under the substantial effects doctrine.
So you think that's a defensible, a sharp and defensible line?
It is a judicially administrable doctrine, and that I do agree with you, Judge, that when it comes to the judges enforcing the Constitution, they should devise judicially administrable doctrines, but I believe it's possible to do so, and I think it's possible to do so even without endorsing the wholesale New Deal expansion of federal power.
All right, now, Michael Gerhardt, I want to ask you, Randy has said that this is not, that if you, with respect to the individual mandate, if you draw a line between economic activity and economic inactivity, that's administrable, that's clear, that's not just letting judges have free rein. And I want you to comment on that point that Randy made.
Okay, I guess the question is who gets to draw that line? And so in this case, Congress finds that economic inactivity could have a substantial effect on interstate commerce. And so that kind of judgment by Congress, it seems to be appropriate to as falling within its jurisdiction. We might have disagreements about whether or not its judgment on that question is sound, but Congress reaches a conclusion that there is a substantial effect on the cost of health care insurance if, in fact, people are not all, in a sense, purchasing it and supporting it, and that in the absence of having universal sort of a universal mandate, there would be a health care crisis, to put it short, succinctly. That's Congress's judgment. That's the line Congress drew. And I think the question for a court isn't whether we could draw a better line or a different line. I think the question for a court is whether Congress had a rational basis for reaching the conclusion that this regulation was needed because otherwise there'd be substantial effects on interstate commerce.
And
so,
Michael, the question occurs, if Congress can do this, what can't they do? I mean, there are enumerated powers in the Constitution, and I don't want to make life difficult for you up here, but what limits on Congress's power, what judicially prescribed limits on Congress's powers are you prepared to recognize?
well, in the realm in which we're talking about, I would certainly concede that there's a tremendous amount of power vested in Congress. I mean, one of the complications we've got is that the world is growing smaller. You know, the economy itself is becoming more integrated. And this is precisely why I think it makes more sense to acknowledge that the critical exercise of power in these circumstances isn't by the courts, it's going to be by elected bodies. I think the limits here are relatively marginal insofar as courts are concerned, but that doesn't mean that Congress can't abide by them, or Congress might not reach different judgments. I mean, this sort of takes us almost full circle back to this notion that, you know, elections matter. Politicians, political leaders make choices. And so those choices, I think, do have sometimes constitutional consequences. They don't have to make those choices, but once they've made them in the exercise of their judgments about what's likely to have a substantial effect on interstate commerce or not, is something courts have to take into account.
All right, any comments from anybody on what Michael Gerhardt said? Randy, you want to come back?
It was not what Mike said. It was, I wanted to make a comment on something that Mark said. Sorry.
You want to comment on something else?
Yes, there's something
Then
that
go ahead.
Okay, thanks. I just...
It's a food fight, Randy.
Mark offered comments about the nature of constitutional amendments and amendments that would bind the future to today's policy consensus. But there's another kind of amendment that you can have that isn't meant to do that, and it's the amendment that he mentioned that I have some involvement with, called the repeal amendment. And a repeal amendment, which would give 2/3 of all state legislatures the power to repeal any federal law or regulation, that's a structural change, and it's basically suggesting that there should be another check on federal power And it would not lock in any particular consensus today on policy matters about health care or anything else. It would simply say that, you know, the states no longer select their own senators, state legislatures no longer select their own senators. I actually think that was probably a good idea to change that, although what we need is a replacement for it, and to give states the power to rescind any or repeal any federal law would simply add another structural constraint to the Constitution and to federal power that would avoid the need, in some cases, to go to courts, because then
Were you saying that was a statutory change?
No, if it were a constitutional amendment, which in fact this repeal amendment, this is a constitutional amendment that's going to be introduced in Congress in the next session, and it is going to be introduced by the speakers of the House of Delegates in Virginia, by the Speaker of the House in Utah, by the Speaker of the House in Texas, and by the President of the Senate in Florida. The repeal amendment will be introduced by those leaders of their houses and will be introduced by members of other houses in the next session. And it's a constitutional amendment to restore a federalism, by which is meant a state check on federal power, and it would put confidence in the elected representatives of the thousands of elected representatives throughout the country to check the 535 elected representatives that are within the Beltway.
Let's get some comments on the repeal amendment from anybody that wants to offer it. As you heard what Randy said, the repeal amendment, which is being discussed particularly among governors these days, is that 2/3 of the state legislatures would be able to repeal a federal provision or a provision in a federal law. And I want to ask any of Randy has been very enthusiastic in advocating that, and I want to ask any of our panelists to jump in and say whether they agree with it or whether they disagree with it. Do you like the idea, Michael Paulsen?
Yeah, I like the idea. I think it's one of a number of possible ways, of substantive amendments that could restrict national power. You could do it procedurally by having a check. The ones I tend to favor are ones that would impose by constitutional amendment a cap on the size of the federal government as a percentage of GNP, excluding defense spending. I would like to see a constitutional amendment writing a permanent cap on income and corporate and capital gains tax rates into the Constitution. And I'd like to see a substantive amendment saying that Congress may not exercise commerce or necessary and proper clause power to compel people to purchase specific consumer products.
All right, any thoughts? Any thoughts on the repeal amendment from you, Mark Tushnet?
Actually, no. I mean, you know, folks will do what they want to do, and then it's my job to figure out what it means once they've done it.
Ted?
I think the repeal amendment is a terrific idea. I certainly support it, but there are very few constraints on government that I don't support. A cynical friend of mine once observed that the First Amendment should have ended after the fifth word: Congress shall make no law. But that being said, I think the repeal amendment is a good idea. It's a good structural constraint. It is consistent with the overall design of federalism. I think it is also likely to be a constraint that, if it were adopted, would be one ticket to ride. I think the only bill we currently see right now that would have any serious chance of being repealed by the state legislatures would be Obamacare, which is why I, like Michael, am more interested in a more permanent self-executing constraint on the expansion of government that doesn't just focus on repealing Obamacare, which I think, as a public policy matter, is a very important thing.
Well, let me ask you this, Ted. Under the repeal amendment, where 2/3 of the state legislatures can repeal a federal provision, don't the more populous states really lose out under that kind of arrangement? Doesn't that leave New York and California and conceivably one day Texas, Ted? Doesn't that leave them a little bit out of in the cold when you say? Come on, folks! I was born in Brooklyn, and I still have an affection for my old state. But what about Texas and California and New York taking a complete backseat to Montana and Wyoming and Alaska under the repeal amendment? Randy, what do you think?
Well, first of all, Judge, I hadn't recognized your Brooklyn accent until today. My son, who is a DA in Brooklyn, should start talking like you, I guess. It depends on what they're for. I mean, there's no reason why Texas and New York can't support rescission or repeal of laws that the rest of the country also wants repealed. But supposing, here's another example. It's not that I think that there'll be that many laws that will be repealed that already exist, but there's a lot of laws that might be coming down the pike that some states might definitely want to resist. In particular, 2/3 of the states might want to resist a legislation that's meant to bail out meant to bail out California and New York and Illinois, who are running great debts because of their own fiscal mismanagement.
Texas too, actually.
And well, we could put Texas in there, but the point is that but states like Indiana, who have their fiscal acts in order, might want to be able to ally with 2/3 of the other states to ward off that kind of bailout, which under the current system they're likely to be subjected to. So this is another good example, I think, of why this structural constraint is necessary and proper.
All right, now I would like to ask for some audience questions, if we may, and you can direct your question to a particular panelist, or if not, we'll just have any of the panelists chime in. You've been standing up a long time, sir.
Thank you. My name is Roman Buehler. I'm with the Madison Amendment Coalition. I was a lawyer for Congress for 14 years, and my question to the panel is there maybe a third way? Some people want a constitutional convention, but that would take several years to probably convene, and there would be some difficult arguments. Other people rely on the political process. Is there a possibility, what's the reaction of the panel, to the possibility that 34 states could pass a resolution directing Congress to either call a convention or propose a specific amendment that they all agreed on? And you ask, well, what could 34 states agree on? Well, maybe it's a procedural amendment, like Randy and some of the other people have been talking about. The Madison Amendment would give states the same power as Congress to propose an individual amendment to the Constitution, empowering every state legislator, right or left. What do you think about the idea of 34 states agreeing on a single amendment and then forcing Congress this year to actually propose it? Because, of course, Congress doesn't want to call a convention. What's your thought?
All right, anybody like to comment? Please do.
Well, Judge, let me jump in on this. In addition to these 460 genuine constitutional convention applications, there are thousands of cases where states have sent resolutions to Congress, memorials to Congress, asking them to propose specific constitutional amendments, but that we don't count as constitutional convention applications. It's just like saying, please do this, please do this, please do this. This would be another please do this type of thing. And I actually think that politically that has very little bite.
Well, but could the states issue, I think the questioner was asking whether the states could issue a limited call for a constitutional convention. You seem to suggest that a constitutional convention had to be open-ended or unlimited. And what I think the questioner is asking is, can there be a limited call, for example, purely for the question of, let's just say, as an example, Obamacare?
Well, 2 points. There could be a conditional call. You could say, if Congress fails to pass such an amendment, then count our light as on for a convention. But the second question is, could you say count our light on as a convention when Congress fails to pass it, but only if the convention is limited to the specific subject? And I think that's just contrary to the meaning of Article 5 in terms of what a constitutional convention would mean. So, but yeah, this could be an effective tactic. Say, we hereby flip our lights on if you don't propose an amendment that does X by time certain, because Congress may, the state legislatures may fashion their general constitutional convention calls in whatever way they see fit.
All right, let's have a question over here. Yes, sir?
Ilya Shapiro of the Cato Institute, where my job is to be a constitutional rabble-rouser. My question is about rights and what role rights play in this discussion about federalism and limited power. Is there any gray area between government powers and constitutional rights, meaning is every excess government power violation of the federal government's constitutional powers necessarily a violation of rights, whether that be under a Fifth Amendment liberty interest, a Ninth Amendment unenumerated right, penumbras and emanations, whatever your preferred theory is, whether that's necessarily so, and also whether in either communicating or postulating our ideas about federalism and limited power, it might be useful to bring in a little bit of rights talk in discussing these issues with the majority of progressives and no small number of conservatives who think that rights, whatever the debate is about what those rights are judicially enforceable, whereas government structures might not be.
All right. Anybody? Yes, sir.
I'll take a crack at it. This is a panel on federalism, and so that's why the focus was on federalism and not on rights. But I do think the existence of the background rights retained by the people, to which the Ninth Amendment expressly refers, is what puts the onus on the government to justify what its restrictions on liberty, are its restrictions on the rights as necessary and proper to an enumerated power at the federal level or to the police power at the state level. So the existence of the background rights retained by the people don't necessarily function as a trump on government power the way we sometimes think of it since the New Deal. And if, by the way, if rights do function as complete trumps on government power, then that's an argument for recognizing very few of them. Because if you had a lot of them, then there would be no government power, and that's kind of a reductio ad absurdum under the Constitution. So the existence of the background rights don't necessarily constitute trumps, but what they do constitute is a shifting of the burden to the government to have to justify its laws as necessary and proper. And then, Judge, I'm afraid that under our system of government, the only forum in which this can be adjudicated is in the courts. So or what James Madison referred to as independent tribunals of justice, who would consider themselves the jealous guardian of the rights of the people. And so that's where I think it would have, their justification offered on behalf of laws would have to be adjudicated.
Ted, do you have a comment?
Two observations in response to Ilya's question. First of all, what I think is very helpful in discussing limited government is to keep the focus on individual liberty, because the entire purpose of limited government was to protect individual liberty of the citizens. It was the understanding that government unchecked is an enemy to the freedom of the people. And I think in terms of articulating the value of it, that's critical. A second point concerning the discussions about whether the individual mandate violates the Commerce Clause. I think Judge Wilkinson's question to Michael Gerhardt was exactly right. If it is the case that the Commerce Clause includes not only every conceivable commerce which might be aggregated collectively such that it could somehow have an effect on interstate commerce, but it also includes the obverse, every conceivable inactivity that if we forced people to do it, we could make them engage in interstate commerce. The end result is very simple. There are no limitations on the federal government's power. If that is in fact the case, two things are clear. Number one, most of Article 1, Section 8 is utterly superfluous. Why did the framers feel it necessary to give Congress the power to create a post office, or to create laws concerning bankruptcy, or to create patent laws? All of those, obviously, you could aggregate together, and they would have enormous effects on interstate commerce. And so if that interpretation is right, Article 1, Section 8 should have just said, if you can find a lawyer who can come up with some theory connecting something to commerce, Congress can do it. That would have been a different Article 1, Section 8. A second point, in brief conclusion, I think the individual mandate crosses a very important threshold, and it's not just sort of an abstract academic distinction between activity and inactivity. The interstate mandate means if you go home, you lock the door of your bedroom, and you sit in your bedroom and do nothing for the next year, Congress can nonetheless affirmatively reach out to you and force you to do something. That's really a very significant shift. And if that's true, there's nothing Congress can't force you to do. It means enumerated powers are gone. And that, at the end of the day, is why I think when the case goes to the court, there's going to be 5 votes to say this is a threshold Congress can't cross, because the alternative consequence is there are no constraints on Congress's authority.
Mark Tushnet, are those congressmen going to get reelected if they start regulating people who lock themselves in their bathroom for a year?
Well, yeah. So, I really don't want to engage in the Obamacare discussion, which is a much more complicated one. But I think they have to lock themselves in the bedroom and put a note outside. And if I get sick sometime between now and 5 years from now, I promise I won't go to a public hospital for health care or a private hospital not supported by charity. Okay, fine, maybe so. I'm not going to, I wrote a book, the title of which was Taking the Constitution Away from the Courts. So, by me, it's fine to say, the folks who you have so much, I have a lot of trust in, should be able to do what they want. Enact Obamacare, repeal it. It's okay by me. That's what elections are for. I like elections. I like elections when they don't come out the way I like them to come out. And so, I don't care that if you can't come up with a judicially enforceable limit on the Commerce Clause. I think politics is a pretty good limit on what we as American people want to do.
Michael?
Thank you very much.
Thank both of you very much.
Yeah, my wife is here. No, just kidding. At least wait till I start talking. Okay? I just want to echo, and may be able to literally echo what Mark just said. I do think that, one of the things that actually that I have always taken to heart as one of the great themes in Federalist Society sort of programs is the notion that I actually think politics matters and politics should matter. In other words, we shouldn't just, as a reflexive matter, think of going to the courts to solve our problems. That has been the heart of a lot of critiques of Warren Court and other court decisions, and I think that's a very effective critique, and I think it's one that I want to abide by now. So I don't think the courts are going to necessarily, at least based on current doctrine, strike down the legislation we've been talking about. But more importantly, I think that there are not very many judicial limits here for a variety of different reasons. And let me just say just as a practical point, and then I'll make one other point beyond that because it'll be impractical. As a practical point, I guess just agree with Ted. The legislation is economic legislation. So I think in terms of the existing doctrine, it's going to get analyzed in those terms. And so the closest case we've got to look at right now is Gonzalez versus Reich, and maybe even Comstock. And those two cases, I think, suggest to me a path the court is likely to stick by. But having said that, let me come to sort of the broader point, which is that I think one of the things we've got to come to terms with is whether or not we still believe in politics, whether or not actually politics is something we think we can trust. And I just, again, to echo Mark's point, I like elections. I particularly like elections when people participate in them. And I'm all for broad participation in elections, and no matter what the outcome. In fact, the broader the participation, the more I trust the outcome. And so that is actually maybe one of the things I want to emphasize here is sort of as modest professor, modest judge, or whatever, I think that let's get as broad a participation as possible, and then I think we can have more confidence in the outcome of those elections.
All right, let's hear the question here.
Thank you, Judge. Clara Neely, Institute for Justice. If the 14th Amendment wasn't written clearly enough to prevent Jim Crow and to have the courts enforce its provisions to prevent Jim Crow, and Article 1, Section 8 wasn't written clearly enough to prevent something like Obamacare, just how clearly do the people have to write a provision in the Constitution to get judges to give them the limited government they obviously want?
Okay.
Michael Paulsen, and then...
Oh, it is hard to write a judge-proof constitutional provision.
Whoa!
Something omitted from this discussion, which probably would be a panel in itself, is whether part of limiting the powers of the national government might include an agenda for limiting the powers of the courts, including prescribing proper methods of constitutional interpretation. But that opens up a whole new can of worms.
Michael.
Yeah, I just want to, actually here I want to sort of point out something that I kind of like about Randy's suggestion, because I think it's a process-based amendment. And there may be the answer right there. In other words, so one way you can in fact constrain judges and even Congress is on the basis of process, not substance, but on the basis of process. And so we have processes now, and that takes me back to sort of my point earlier, which is, do we trust them or not? Many of us might not. But if we don't, then maybe we ought to think about how to tinker with that process and refine it.
All right, one last question over here.
Okay, I've got a question for Mike Gerhardt, and I'm Brian Bishop. I'm from the Ocean State Policy Institute, and just to make it quick, I'm the kind of Roger Pilon of Rhode Island, which is my role in attending. And Mike,
I saw Roger here, by the way.
Yeah, he is.
Okay.
And I hope I do him justice. I'm wondering when, totally coincidentally, you cited the quote from Judge Wilkinson's opinion.
Yeah, it was a complete coincidence, by the way. Right.
Of course, the thing that struck me is I don't think that Randy would suggest that North Carolina farmers deserve justice quicker than the slaves, but I think he thinks we should have sped it up for the slaves rather than slow it down for the farmer from North Carolina. And what I'm wondering is, all of your suggestions about the potential for political solution they're highly majoritarian in character. They don't speak to the kind of structural concern of checks and balance of minoritarian interests that I think were already endemic in the Constitution. And I'm concerned that you say, I'm fine if you amend it. I'm wondering why we have to amend it, to get what's there already.
Well, I think it's a good question. I think what I would say is that I'm not suggesting that majoritarianism necessarily should prevail in all circumstances. There are limits, of course. Some of them are substantive, some of them are process-based. I have suggested, I think, to some extent, that courts are not the institutions necessarily to expect further limits on the kinds of things that come out of Congress that are at least economically related. But in terms of minority protections, there are, I guess a lot depends on the kind of minority you're talking about, what the thing might be that defines that particular minorities. There's some minorities that happen to be political minorities. And so political minorities are self-defining. So if you happen to be taking a position that is not supported by most people and that loses, that's something that in fact is part of the political game. I think the real question is, when is a minority entitled to prevail substantively? And that is a question, of course, of constitutional law, and it takes us back to the question about rights and the limits of federal power. I don't think either, at least based on current doctrine, rights or federal law precludes government from doing what it is doing now. I do think there's a process that's still available that may serve as a check. You talked about checks and balances, and surely checks and balances are important because, after all, at the end of the day, Congress is constructed, I think, largely to get things not done, not to get things done. And the fact that it does get something done is sometimes actually quite miraculous. And so that part of the constitutional structure, I think, continues to persist. And what that suggests to me is that politics matters.
All right. I want to thank these 5 panelists for doing an absolutely spectacular job. I think each one of you made magnificent contributions, and I just really have enjoyed being with each of you. And thanks for being such an appreciative audience. And we'll now take a break, and I hope everybody has a fabulous convention.